The New South Wales Government recently introduced tough new laws as part of a zero-tolerance approach to drink driving. From the 20th of May 2019, police were given the power to suspend a person's driver licence immediately for any drink driving offence. This now includes low-range drink driving offences. Previously, police could only issue on-the-spot suspensions for drivers charged with mid-range and high-range PCA offences. Now police can suspend a person charged with low-range PCA, which is a reading of between 0.05 and 0.079. So what does this mean? It means that all drink drivers in New South Wales now face an immediate loss of licence. First-time offenders will be suspended for at least 3 months and will receive a fine of $561. The same penalties will apply to those caught driving with illicit drugs in their system if it is confirmed by laboratory testing. So what are your options if you receive an automatic suspension? If you have received a fine and an immediate loss of licence for a drink driving offence, you can lodge an appeal with the local court. However, it is important to remember that the suspension remains in place until you appear before the court. The court can either set aside the suspension, which means that you get to keep your licence, or it can vary the suspension, which means that the period of the suspension is reduced. So how do you appeal? A person can appeal by filing a notice of appeal with the local court. How long does a person have to appeal and what is the process? It is important to remember that the notice of appeal must be filed within 28 days of the date on which you were suspended. However, it may take up to 4 to 6 weeks before your matter is listed to come before the court. So what factors are relevant to the appeal? It is important to distinguish between a suspension of licence and an automatic suspension of licence that is issued by the police. If you are appealing an automatic police suspension, you must show the court that there are exceptional circumstances why your suspension should be lifted or reduced. The exceptional circumstances test sets quite a high standard because immediate licence suspensions are usually imposed for serious offences. The law does not specify what are exceptional circumstances, but reasons such as needing a licence for work are not considered exceptional. The circumstances surrounding the offence will also not be considered by the court. Contact Baker Love Lawyers for more information.